Okay, so let's talk about the costs agreement itself. So let's start with relevant law. So you're going to find the relevant sections. I'm going to set them out on the next couple of slides, but as usual, you can read. You don't need me to read them for you. My job here is to point out some things that you might not have thought about yet. So again, look at Div 4 and sections 179 and 180 in particular. So 179 is the client's right to a cost agreement, and section 180 sets out the requirements in relation to making the cost agreement. Section 181, it deals with conditional costs agreement. And this is where I'm going to spend quite a bit of time. These can be a little bit confusing, particularly as you've heard me say, you can't have contingency fees in Australia. Conditional costs agreement, they're probably not overly well named, to be perfectly fair, but essentially these are the circumstances where some or all of the payment might be conditional on a particular outcome, and we usually refer to these as no-win, no-fee arrangements. So let's, I just want to highlight the key things for you to look at. So as a general proposition, don't forget that contingency fees are banned. So section 183, in Australia we cannot have contingency fees as such, but conditional costs agreements are allowed, and these are our no-win, no fees. So in other words, it's possible to put don't know what I'm doing there. It is possible to put a condition in a cost agreement that you'll only be paid for the work that you do if you reach a successful outcome. So essentially we call them conditional cost agreements. They need to be made in writing, and they need to be made in plain language. They have to include all of the conditions that you define to be a successful outcome, and they need to be accepted in writing or they cannot be enforced. So this is actually a good example. I should add this to my list when I talk to people about contract law, where statutes of fraud type successor legislation. In order for the retainer the contract, that includes a conditional fee arrangement between a lawyer and their client, it's a statute of frauds exception. What else do we need to say about them? Often what happens is a lawyer will believe, that the client has a good chance of success, and in those circumstances they might include what they call an uplift fee. So this is an additional payment on a successful outcome. The maximum amount of that uplift or additional payment will be 25% of the legal costs, excluding disbursements. So the cost agreement needs to be clear on how the fee will be calculated, what you expect the fee to be, and what factors can change the final fee calculation. It is worth remembering, and again, a detailed look at section 181 will draw this out, but you cannot have a conditional costs agreement in relation to a criminal matter or a family law matter. So as I mentioned before, the law in Victoria doesn't currently allow clients to be billed on a contingency fee basis. So a contingency fee is where the fees are calculated based on how much money you might get for the client from a payout or from a settlement or something like that. So C183 for the ban, and understand that really this goes to that ethical requirement for independence, and essentially it's seen so far in Australia anyway to be a bridge too far, that the amount of money that the lawyer earns is contingent upon the success or otherwise of the matter. So here's a look at 182, which is where that uplift fee comes from. Uplift fees, they've been a little bit controversial along the way. I'm not sure how much they're being used in private practice, in the sense of, I'm using private practice very broadly there, in law practice where the persons who are being advised are individuals as opposed to companies or businesses. I'm not seeing them significantly often in commercial practice, and I think there's probably commercial reasons more than anything else for that. They could be a good way for some lawyers to make justice more affordable and accessible for clients who otherwise wouldn't be able to afford to enter into litigation, because it motivates success, and essentially when the uplift is paid often enough, that effectively provides sufficient income for the lawyer who's, battling away at litigation for the battler, that they can afford to take a few losses because the uplift covers their other costs. Under these kind of arrangements, the lawyer usually charges no fee or a reduced fee if the client isn't successful. I guess they're kind of ethically ambiguous when you think about it, both conditional and uplift fees. On the one hand, they're the types of fees that can help clients access legal and substantive justice. However, many think that they're a dangerous kind of mechanism that damages the purity, probity, and integrity of the lawyer-client relationship. I guess, again, the ethical lenses that you look at the world through, which we've been exploring right from the very beginning, will inform you in relation to the way that you feel about the availability of uplift fees or conditional fees. I'd be really interested to know what you think. And here, just on the screen, so that it's easy for you to find, is section 183, which provides that contingency fees are prohibited. You can see there that there are significant penalty units in place as well. I can't remember off the top of my head what a penalty unit is at the moment, but 100 of them is a significant fine. So the main type of contingency arrangement or conditional arrangement, let me use the language precisely, conditional arrangement, is under 181 and is the no-win, no-fee mechanism. It's important to go through 181 carefully. I've extracted the following key elements from it. Any conditional arrangement under 181 needs to contain a statement that the client has been informed of their rights to get independent legal advice before entering into the costs arrangement. I always find this a little bit amusing. I probably shouldn't, but it's a really good example of when you need a lawyer to protect you from your lawyer. What happens if the lawyer that you are getting to advise you on your conditional costs arrangement actually wants to charge you a conditional cost arrangement? Do you need another lawyer? Oh my goodness, it's like an Escher diagram in my head. Anyway, they do need to be written in plain language. And they need to be, well, clearly written in writing, and they need to be signed by the client. That doesn't mean, and we've thought about the technologies here, that they need to be on paper and a wet ink. They could be signed through any of the kind of arrangements that are acceptable under the Electronics Transactions Acts in each of the states. And they also contain a cooling off period, 5 business days, so the client can go away and think about it. Cost agreement generally, it is really important to make sure that they are clear. So Equuescorp and Wilmoth, Field and Wayne is a key case from the Victorian Supreme Court in this area. In that arrangement, a cost agreement stipulated a discount rate of $66 and a normal rate of $400 per hour that would be payable on success. So essentially, they provided for 2 different hourly rates depending on what the outcome was. Justice Burns said when the fees were disputed later, that there was an uplift in excess of 25% and therefore it was unlawful. So stipulating that the rate is a discount and that it's your standard rate on success will not get you over the line, that the most that the increase can be is 25%. On appeal, the Court of Appeal decided that it was an ordinary conditional cost agreement and that the normal rate should be paid on success. So one of the biggest issues that really comes out with a no-win, no-fee disclosure is really the discussion about, well, what's a win? How do you know in a legal dispute that you were successful? So in the 2002 Queensland decision of Baker Johnson Lawyers and Jorgensen, the settlement itself was not sufficient to cover costs, and the law firm sought to recover additional money from the client, and the court said, well, that's not a win, and so they couldn't recover the costs. Even so, it's worth remembering that whether you're successful or not successful, the client in a conditional costs arrangement may still be obliged to pay disbursements even if they are unsuccessful. And so it's really important that there is full disclosure of what the settlement money would be required to clear both the amount of professional fees and the costs, and it's clear to the client what the outcome will mean for them. And clearly, and we've talked about this already, the uplift needs to be, that might be charged, needs to be disclosed, and it's up to 25% of the legal costs, not 25% of costs and disbursements. It's also really important to have a look at section 185. I've got it there in full to save you looking for it, because these set out, and we talked about this a little bit in the last video, the circumstances in which a cost agreement will be void. And the most important of these is when there isn't sufficient disclosure. So the two are related to each other. But in a nutshell, a cost agreement that contravenes or is entered into in contravention of any of the provisions of this division is void. So failure to comply with the disclosure obligations, the costs must be assessed before the law practice can seek to recover them. So go back and see section 1781. Now this is really important because it affects the timing that lawyers need to think about when they're seeking to recover unpaid costs from their clients. Because unless and until there has been an assessment of those costs or the dispute has been resolved, you cannot enter into any proceedings to enforce the costs agreement. It's also the position that a law practice cannot recover any amount in excess of the amount that the law practice would have been entitled to recover if the cost agreement had not been void, and needs to repay additional amounts. A law practice that has entered into costs, sorry, let me find trying to look that way, look over here, too many things going on. That's really unuseful, not useful in the podcast version of this, isn't it? Let me stop. So a law practice that has entered into a cost agreement in contravention of section 183 is not entitled to recover any amount in respect to the provision of legal services to which the cost agreement related, and must repay any amount received in respect of those services. So compliance with 183 is specific, is really, really, really important. The other thing that is worth thinking about here is what we're talking about when we're talking about costs and disbursements. Which ones can be covered and reclaimed and which ones cannot. So lawyers have an implied authority from their clients to incur ordinary disbursements. So this could include things like service fees, court filing fees, and these are usually contractually dealt with in the retainer, but as a matter of law, there is an implied term that you have authority to enter into contracts essentially as the agent of your client to commit to those kind of costs. However, it's important that the client is informed and that their approval is obtained before any major expense is incurred. So what are a major expense? They could be things like engaging an expert witness to prepare a report, or to engage a external counsel, so a barrister or a QC, to advise or to advocate on behalf of the client. Clients who enter into conditional costs agreements in a litigious matter where the payment of the cost depends on a successful outcome may still be required to pay those disbursements if their claim is unsuccessful, but they'll only be required to do that if the costs agreement specifies this, which, let's face it, is the usual case. So the lady on the slide here with the big hair is Carol Foreman. She was a really well-known family lawyer, a so-called husband's lawyer back in the 80s and 90s. So the circumstances leading to this case occurred in the 1980s. She'd been headhunted to join Clayton Utz. She was maintaining her practice, but she was under incredible stress, I guess, under incredible pressure to increase her billings. In court, she swore that she had given a particular client with whom she ended up having a dispute about fees, that she had given that client a standard cost disclosure, and she'd renewed it a couple of months later. It turned out, in fact, her legal assistant, who is also on that slide, I believe, ended up giving evidence that demonstrated that she had forged her timesheets. There was another copy on record at the file, but at the firm, but the version that was submitted to the court had been forged, and she had she destroyed the original in some way. So ultimately her fee dispute with the client was settled, but even so, disciplinary action was brought against her because she had deceived the court. She deceived her colleagues, she deceived her client, and she deceived the other lawyers in the matter. And ultimately, she was struck off. Now, essentially, this is the highest punishment, for want of another word, that the court will give a lawyer for a breach of ethical duties. But it is really, I think this case remains really interesting because it shows how the pressure on lawyers to bill, combined with the way both the rules around billing and our general obligations to our client and to the court all coalesce and create a set of standards, very high standards, by which we need to commit to act. It's also, as I said at the beginning of this video, I think one of the things that we really need to pay attention to is the extent to which there are additional standards of disclosure required in litigation matters as well. And so in a litigation matter, prior to settlement, it's important that the lawyer provides a reasonable estimate of the costs payable to the lawyer on settlement and the costs that would be payable to the other party if applicable. The biggest issue here is that it's very difficult to foresee a single figure. And so it's really important to ensure that the clients are advised that if the matter is not settled, that there are still going to be costs, and that those costs, if the matter continues in litigation, are going to increase. It's also in litigation matters part of the disclosure requirement. You'll remember from the last video, I might not have talked about it directly, but the way the law works is that there is a requirement to ensure that the client understands that legal aid may be available as an alternative. In practice, legal aid is very rarely available, and actually in practice, advising a client that legal aid might be available actually just gets their hopes up and creates a whole heap of other problems. But at the same time, the requirement is there, so it needs to be done. Now, our clients will often come to litigation and costs agreement thinking that they are on the side of right, that they're going to win, in their litigation, and that means that their costs are going to be paid by someone else. And so it's really important to ensure that the client understands that even when they get a costs award made in their favour, that is very rarely going to cover all of their costs in relation to the matter, even in a no-win, no-fee situation. Ordinarily, the courts will exercise their discretion to award costs in civil proceedings by giving an order that costs follow the event. In other words, the winner, let's call them that, will recover most of their costs from the loser. So this is what's called the cost indemnity or the cost shifting rule. Technically, the cost indemnity or the cost shifting rule is really a custom or a practice rather than rule, actually, because the practice is discretionary. The court can make awards as it considers appropriate. The rationale of the rule is to discourage hopeless claims and defences and to induce a willingness to compromise or to settle and to ensure that the winner keeps most of the fruits of the victory. So authority for that proposition is I never know how to say this, Ridehalgh and Horsfield. I should have put it on the slide to make it a little bit easier for you. Ride is Ridehalgh and Horsfield. So in criminal and family law proceedings, parties normally will bear their own costs, so there is no costs award as such. And it's worth noting that in the USA, which is one of the most litigious places in the world, this pretty much applies in all cases. The family court does, however, have a power to make a cost order where circumstances justify it or the proceedings were frivolous or vexatious. So have a look at section 117 of the Family Law Act in relation to that. There are some other no-cost jurisdictions as well, for example, the Fair Work Tribunal. I think Parker and Evans, the diagram that they have in Chapter 8, so Figure 8.1, is a really useful way of kind of getting your head around what is and isn't included in a costs award. So a court will usually decide essentially on the basis of what is fair and equitable. And the cost indemnity rule works to say that if you win a legal action, you're the one who's entitled to have the costs that are reasonably incurred and reasonable in amount paid by the other side. So in the uniform law, we refer to these as standard costs and ordinary costs, and they're calculated on an item or a remuneration basis under a court scale. So what are reasonable costs? Sorry about my dog. Reasonable costs are all those costs which a lawyer was justified in incurring in running the case and in attending to the client's needs for information. A successful party can also recover disbursements, so filing fees, witness reports, barristers' fees, etc., all subject to that reasonableness criteria. On the whole, standard costs tend to fall in the realm of about 60 to 80% of the overall costs. They used to be referred to as party costs as opposed to solicitor client costs. So make sure that you read Parker and Evans, and Del Pont will fill in the gaps with the case law that supports this. But the big issue really from a cost agreements and a disclosure point of view and complying with the uniform law is making sure that you're in a position to describe clearly and in plain language what the consequences for your clients will be. So when it comes to dealing with either setting aside costs agreements or varying them, the courts have been treated them quite strictly. So they've seen them as being a lawyer's opportunity to exercise influence over the client. They're recognising the fiduciary nature of the relationship and the disparity of information, the information asymmetry, the moral hazard issue. And so under the common law, the courts played a pretty significant role and they exercised jurisdiction to set aside or to modify costs agreement that were not fair or were not reasonable. Under the Uniform Law, a cost agreement is on its face evidence that the costs disclosed in that agreement are fair and reasonable if the requirements governing cost disclosure and cost agreements have been met. So again, complying strictly with the requirements of the Uniform Law are absolutely key to ensuring that you can enforce your contract and recover your fees over time. And so there's little scope for the common law these days to set aside cost agreements in the uniform law jurisdictions. So that's all I want to talk about here. There's quite a bit of reading to do, and in the next video we'll talk about the process for recovering unpaid fees from clients, what's involved and where the tricky bits are. I look forward to talking to you then, tomorrow my time.